Alright, I'm doing some readings on natural law first, and then I'm going to get into wireless and mobile security textbook readings. But I want to finish this. Well, this one I just pulled up. I just found it on Google. I'm going to skip through this to support my reading on the left there. Just going to see. Okay, I was looking at some of this. I didn't really, still wasn't telling me what it was. Seems like this is definitely a legal kind of history and understanding, which I don't have. So I'm sure there's some sort of teaching on this kind of stuff that you might be able to learn. Like this stuff I'm not really, I mean I'm following along, but it's not answering what I want it to answer. Use is common to all men, whereas lex is common to one man. And this is definitely going to be useful to read through fully, but that's not the intent I'm going with right now. Lex is a species of ius. Lex is a written constitution. Lex commands what is just and prohibits the contrary. Lex is so named because it binds, or because it is read as writing, or because it is legitimately functions of rewarding, or because it legitimately functions by rewarding those who observe it and punishes those who transgress its rules. Lex is sometimes defined narrowly and sometimes broadly. An example of a narrow definition is when a statute of Roman people is called a lex. A lex is the common opinion of men who are learned in the law. Lex is broadly defined when it is used to describe all reasonable statutes. Whence lex is a sacred command, ordering honesty and prohibiting the contrary. Consequently, it is the rule that governs just and unjust people. Pretty interesting. Okay. I'm not finding good results either. Hmm. But the whole page is just the whole page is just footnotes. The 2 whole pages is just footnotes. 3 whole pages, 3 whole pages are just footnotes. Dude. Okay, I don't think I'm gonna get the answers I need. I don't know where I left off on this. Actually, that other article was pretty useful in understanding a little bit, getting closer understanding at least. What? Come on, highlight. So lex just means law in Latin. But can also be ius. There's, I guess, 2 different versions. I don't know. Use. I don't know. So in every rule of external human conduct, or basically in every law, there exists materia and forma, matter that is the changeable and concrete material, and forma, the intellectual element of a will content, universally contained in every law. So like, you shall not steal. There is a materia and a forma to that. So the materia, changeable and concrete material, is the act of like taking one object from another person, and then the forma would be the fact that you're abridging upon, you're infringing upon someone's like property, I suppose, or some sort of like independent, like there's some sort of more abstract intellectual element of a will content. Let's see if he expands on that a little bit more. Employs the distinction to clarify the philosophy of law as applied to in the entire legal system. Immediate problem is to test its application only to such portion of our constitutional jurisprudence as has developed under the due process of law clause in respect to legislation of the several states. Demands that we define the use of the term for our immediate purpose to constitutional law. Form is described as the uniform method of ordering. That is, in constitutional law, the element which gives constancy and unification to our jurisprudence, the universal element thereof. I don't know if that made it any more clear, to be honest. The uniform method of ordering? What does he mean by ordering? I guess that's the first thing. What do you mean by ordering? Ordering as in sequencing? Or ordering as in demanding? A uniform method of ordering. That is, in constitutional law, the element which gives constancy and unification to our jurisprudence, the universal element thereof. Uniform method of ordering is the element that gives constancy and unification to the jurisprudence. Okay. So ordering as in relation to itself and others, regarding the whole of jurisprudence. So it needs to, the form is how it relates to the rest of the full jurisprudence. Something like that. Whereas the materia can be only those concrete decisions, which have manifested themselves from time to time as the court has had occasion to pass upon the validity of statutes of the states under the amendment. I don't know if that was that good of a definition there. Materia can be only those concrete decisions which have manifested themselves from time to time as the court has had occasion to pass upon the validity of statutes of the states. So materia being the concrete decisions, whereas the forma is more of the universal element that is applied to and then is manifested within each materia. Is that even anywhere close to what? I think I'm close. I feel like that makes sense in my mind. That like I'm grasping that. That seems to make sense. There is a form and a materia, whereas a materia can be an exampled manifestation of a form. Not necessarily a manifestation of a form, but a manifestation of an instance, or just an instance that a form can apply to, that may appeal to a form or contains within it a form that relates to the broader jurisprudence. I feel like that makes sense to me. I gotta think of like a good example to explain that. I don't have a way to explain that right now. I got the first step where I'm starting to understand what it's trying to say. And now the next step is to like redefine it in my own words with an example. Or not necessarily redefine it, re-say it. Form is described as the uniform method of ordering. You see, like I wouldn't describe it as that because that's too abstract. The element which gives constancy and unification to our jurisprudence. Okay, so I'm not like a law person, so I'm not good at this. Law person. So I'm not familiar with like a specific like what would be a good example that comes to top of mind. How to understand this. Maybe, okay, so like a very common thing would be like freedom of speech. So where the materia can be some specific instances or decisions made on specific cases is the materia. The concrete decisions of an instance of a materia. So here's one case, and it's got certain facts in it, and those facts of this case is and then the decision of the case is the materia, whereas the form is what is appealed to for the ruling or the determination of the case. So the materia appeals to the forma, or is like, I guess they can be both contained within themselves, but that's not the way I meant to say it. They can both be present in the same case, or they are, but it's just that the form is the portion that is appealed to the jurisprudence, which is the full body of law, and the materia is the specific decision in a specific circumstances of facts. So it's like the applied forma, essentially. Materia is the form applied upon a specific instance of facts, circumstance of facts, and the decision thereof. I feel like that makes sense. I feel like that makes sense to me. Materia can be the applied. The materia is the decision of an of a forma applied to a particular circumstance of facts. Does that make sense? I think that makes sense. Is that correct? I don't know. This is why it's good to have teachers, honestly. Like, teaching yourself stuff is pretty good, but then when you have questions, it's like, how you need someone to get you on track, or at least to confirm whether or not you are on track or not. Like where you might not know which is the correct track to be on, you can ask questions and they can then help you identify Yeah, I feel like that's a downside of autodidact autodidactism. I don't even know what the word is. Autodidact. I wonder if that it would be correct. So let's just keep reading and see if I can get that on my own. Let's see. So the abstract must not be confused with the concrete. Neither must it be thought that the pure form can be fully expressed in the concrete. The abstract ideal can never be expressed or fashioned into concrete positive being. Okay, interesting. On the other hand, the form and the matter cannot be entirely separated. Okay, I feel like that makes sense. That is in accordance with what I was saying. Cannot be entirely separated because you cannot have the decision. If you take away the forma or the form, then the material falls apart because it is appealing to the forma. I don't know if that's a correct way of looking at it, but in my eyes, it seems like that is a good approximation, a good step, a good guess of how I'm understanding this right now. The materia is appealing to the forma. To get to the decision. So they cannot be separated. But there's also an abstract and a concrete, whereas the material may focus more so on the concrete elements and the form is the abstract. They're not really, can't be confused with each other, cannot be fully expressed. Abstract cannot be purely expressed in the concrete, which makes sense. Not be fully expressed, because the forma can apply to many different instances of concrete instances. But any one instance is not fully embodying of the forma. Okay. I feel like I think I'm on the right track here. I think I've got it. I think I've got a general correct interpretation here on this. I'm glad I'm reading this again because I think the first time I kind of just read this and didn't pay attention too much. Let's see. So, it cannot be entirely separated. They are always found united. Neither exists prior to the other. Since, on the contrary, as has been said, they make their appearance only at the same time and in union with one another. Their discovery necessarily involves a critical analysis of an already existent synthesis. There's supposed to be a period here. How this synthesis occurs does not bear on the question of systematic analysis as such. Okay. For purposes of the present discussion, we have to start from the proposition that throughout our entire experience, our impressions and aspirations are synthesized, and that in these composite experiences can be distinguished the uniformly determining method of ordering on the one hand, and the particular facts determined thereby on the other. I feel like that's justifying what I just said, what I was reasoning here. Composite experiences can be distinguished uniformly. Here. In that these composite experiences can be distinguished the uniformly determining method of ordering, and on the one hand, in the particular facts determined thereby on the other. Oh, you can't do multi-page things. Okay. In these composite here. Okay, I'm following along here. We must distinguish then in our thinking between those uniform methods of ordering which, in constitutional law, lend continuity to the fabric which the decisions have woven, and the particular conclusions in concrete cases which constitute the matter ordered thereby. Okay, so hold on, let me reread that, because that went in and out. We must distinguish then in our thinking between those uniform methods of ordering which, in constitutional law, lend continuity to the fabric which the decisions have woven, so the full totality of jurisprudence, the element that is uniformly ordering a specific instance to the full jurisprudence, or the fabric of which the decisions have, so the full past of decisions must be in accordance with the forma of those, because they have a forma that is a totally unifying element of all the past decisions, okay, that weaves together and constitutes the full jurisprudence, and the particular conclusions in concrete cases, the material, which constitute the matter ordered thereby. You see, the way lawyer, they want to just write in ways that are distinguished of academic intellectuals, right? They want people who are trained in reading certain ways and in writing certain ways, so it's less accessible to the common people, thereby creating a moat or barrier. Like, there's really no real reason to write in the way that they're writing this, other than the sake of, like, how did one person put it? Intellectual masturbation. Really, that's the only that's what this is. That's what much of probably law is, in a sense. That's why they call it lawyer speak. Which I'm seeing there's like an erosion of this as it relates to like information security and like policies, or what their goal is to be more vernacular, more written with vernacular, with the common tongue, with easy interpretation, rather than with the moat of intellectual pseudo language. Is the way I'll call it. But interesting. Okay. So, but basically you can just break that down into like simple words. You can just break it down into the simple idea that's being conveyed here, which is like the way this last sentence is, and the particular conclusions in concrete cases which constitute the matter ordered thereby. You could literally, put it into retard speak and say, we must distinguish then. This one is a little bit harder to break down into something more simple, because this actually is a more abstract, kind of more complex topic here. But then the particular conclusions, you would get from the case. You can honestly just kind of, which thereby constitute the matter ordered thereby. Whatever. I'm not smart enough for any of this kind of stuff, but it's understandable what he's saying. Okay, totally makes sense. I think this vindicates what I was saying earlier then, and the other pieces, but concrete cases, which, so I don't know, I guess I'm just going to highlight this whole thing. Whatever. Yet we are to look for these two elements together, for the one does not exist without the other. I already kind of highlighted that, right? Cannot be entirely separated. Distinct from these two elements, for philosophical purposes, there is still a third element involved, namely the relationship between the universal, unifying element and the concrete matter. Interesting, okay. So there's the universal element, the form, the concrete matter, And then there's the content. I'm doing this, actually, I'm gonna change this to red. Because then we have the form, materia, and content. Okay, so the content is interesting. So now I want to see how that changes now that this is introduced in here. By introducing into constitutional jurisprudence the unchangeable and immutable element of reason as a standard, we have provided a universal of conditioned and unvarying validity. It is here that our natural law becomes truly philosophical. Legal history has had faith that it could find the everlasting, unchangeable legal reality in which we might rest and could enable us to establish a perfect law by which human relations might be ordered forever without uncertainty and freed from need of change. It is thus that our standard of reason provides a genuine philosophical basis for an enduring constitutional jurisprudence. I don't know if I want to highlight that. I think I do, though. It is thus that our standard of reason provides a genuine philosophical basis for... Okay, so he's arguing that... Okay, but I want to go back to this content here. Content is the relationship between the forma and the materia. What would that relationship... That's pretty abstract thinking right there. So in the case of the abstract universal ideal of freedom of speech, like you have a freedom to think and freedom of speech, and then in specific instances you might have the materia, which is a concrete facts of the case, and then the relationship between those two, how it applies, is the content. I don't know why they chose the word content. I would choose a different word because that's confusing with materia almost, but I guess that's fair. And then their relationship. Okay, I guess that makes sense as a third. I was about to say, well, I think you could just get rid of the content, but no, you can't, because then you might have the same form, the same material, but then you can argue the content of how they relate, and the content can definitely be argued, assuming you already establish, assuming an agreed form, an agreed materia, there's still room for variance in the content. Okay, fair enough. Makes sense to me. A number of years ago, Mr. Justice Holmes said of the doctrine of reasonableness as applied in private law, when we rule on evidence of negligence, we are ruling on a standard of conduct, a standard which we hold that parties bound to know beforehand, and which in theory is always the same upon the facts, and not a matter dependent upon the whim of a particular jury or the eloquence of a particular advocate. That is good. Fair enough. Yes, that is good. Reasonableness. Doctrine of reasonableness. And as to the same element of reason in public law, where the police power of the state was involved, the words of Mr. Justice Eakin in Stetler versus O'Hara have a far-reaching significance. There have been many attempts to define the police power and its scope, but because of confusing the power itself with the changing conditions calling for its application, many of the definitions are inexact and unsatisfactory. The courts have latterly eliminated much of the confusion by pointing out that instead of the power being expanded to meet new conditions, the new conditions are, as they arise, brought within the immutable and unchanging principles underlying the power. So the constitutional question represented in due process of law as applied to statutes under police power, it is essentially a philosophical question because it involves the element of unchanging validity. A great deal has been said by the courts about the question of reasonableness, whether it is a question of law or a question of fact. Austin, long ago, pointed out that it was neither, but rather a question involving the relationship between the given law and the given facts. When Stamler calls the content, this question involving a pure intellectual process is primarily a moral one. This, it must be, is what Mr. Justice Holmes has in mind when he declares that the standard of the reasonable man is not a legal standard at all. Okay, hold on, wait. Because I was kind of like thinking about something else while I was reading this. So, a question about reasonableness, whether it is a question of law or a question of fact. But it's neither. Rather, a question involving the relationship between the given law and the given facts. The content. Bada bing, bada boom, the content, baby. What Stammer calls content. Oh. I swear I didn't know that was the next few words. I didn't know that. Ugh. Keep doing this one. I want to like get rid of this. I don't know. Question involving a pure intellectual process is primarily a moral one. This, it must be, is what Mr. Holmes has in mind when he declares that the standard of the reasonable man is not a legal standard at all. Insofar as the standard becomes incorporated into the law, many jurists will call it a legal standard, but its application implies the exercise of what is fundamentally a moral judgment. Okay, fine, I'll do the whole thing. Speaking of the philosophy of law, says, by the philosophy of law, we understand the theory of that which in judicial discussion is assumed to be of unconditioned universal validity. Scientific propositions do not involve elements of unconditioned universal validity. Science is concerned primarily with the general, thus defines what he conceives to be the fundamental questions with which the philosophy of law is concerned. What is law? Why does it bind? Upon which principles are laws just? Declares these cannot be solved by the consideration merely of definite historical law. They are questions involving a consideration of that which is assumed to be of unconditional universal validity. The various answers which the courts have made to these three questions as they have arisen under the police power in the 14th Amendment. My highlighting strategy is so bad on this. I could 100% make it so much better. Oh, I kind of want to redo that now. There are questions involving consideration of that which is assumed to be of unconditioned universal validity. Various answers which the courts have made to these three questions as they have arisen under the police power and 14th Amendment indicate the relation of the doctrine of the reasonableness to each. The answer to each question involves considerations for the treatment of which science is jejune, No idea what that is. And empty. What on earth? Jejun? Jejun? Bro, just like, don't use those words? Dude, nobody knows what that means. Jejun. And somewhere, I thought I said somewhere emo band. Not interesting. Dull. Lacking maturity. Bro, really? You see how, like, it's just intellectual masturbation? You know what I'm like? You see what I mean? Like, you could just say dull. But no, it's Jejun. Bro, get out of here. Get out of here. There's the door. Come back when you're normal, bro. What a joke. Is jejun and empty, but to which philosophy is germane and pertinent. You know what I'm talking about, bro? You know what I'm talking about? Jejun. Jejun. Oh, that's so jejun. Lacking in nutrition. Surprised by their jejun response to our problems. Jejun. I'm gonna start using that exact sentence. Surprised by their jejun responses to our problems. What a jejun response. That's not even funny. Why am I laughing? Okay. Science has in its place in constitutional law in the determination of the facts for the creation of the materia. Okay, so hold on. So there's an argument. So let's see. Fundamental questions with which philosophy of law is concerned. Hold on. Actually, now this is important. Now I want to go back and highlight this. But not that. So now I want to delete. Okay. Scientific propositions do not involve elements of unconditioned universal validity. Science concerned with primarily the general. The answer to each question involves considerations for the treatment of which science is jejun and empty, but to which philosophy is germane and pertinent. So basically, answering those, science is not it's not capable of answering these in a philosophical context because they are questions involving consideration of that which is assumed to be of unconditional universal validity. Yet philosophy is germane and pertinent to being able to answer those. Science has its place in constitutional law in the determination of facts for the creation of materia. I gotta change. I don't know. I gotta find a good way to do this. In ordering that the content may be established, but with the pure form, philosophy alone is concerned. So this is the topic of this portion here. Okay, so philosophical our standard of reason provides a genuine philosophical basis for an enduring constitutional jurisprudence. constitutional question presented in due process of law as applied to the statutes and the police power is essentially a philosophic question because it involves the element of unchanging validity. To support. Kind of. A question of reasonableness, whether it is a question of law or a question of fact, is that it was neither, but rather a question involving the relationship between the given law and the given facts, which Stammer calls the content. I guess this can all be blue. This is supporting argumentation. It's a philosophic question because it involves the element of unchanging validity. I suppose this relies on this. So the power being expanded to meet new conditions, the new conditions are, as they arise, brought within the immutable and unchanging principles underlying the power. Because of confusing the power itself with unchanging conditions calling for its application, many of the definitions are inexact and unsatisfactory. So it was rather a question involving the relationship between the given law and the given facts. Content. This question involves a pure intellectual process. Involving a pure intellectual process is primarily a moral one. The standard of reasonable man is not a legal standard at all, insofar as the standard becomes incorporated into the law. Many jurists call it a legal standard, but its application implies the exercise for what is fundamentally a moral judgment. Okay, so that just continues, I guess, on the idea of the support. Supporting of this one here. It provides a genuine philosophical basis for enduring constitutionalism, whereas scientific propositions do not involve elements of unconditioned universal validity. Science is concerned primarily with the general. Fundamental questions with which philosophy of the law is concerned. What is law? Why does it bind? Upon which principles are laws just? There are questions involving a consideration of that which is assumed to be of unconditional universal validity. I mean, this itself is not support, but this adds to the supporting information. I don't know, dude. I don't know. I don't have a good highlighting approach system. Answer to each question involves the considerations for the treatment of which science is jejune and empty, but which philosophy is germane and pertinent. Can I highlight this also as red? Thus, natural law with its philosophic element must be kept distinct from the factual determination involved in the matter. I don't know. There's not really a difference between my blue and yellow ones. I don't know why I'm doing that. In the latter, the first question is one for science, the matter. Factual determination involved matter. Here there is no drawing of the line, no pure form is involved, but only the most expeditious method of determining the factual foundation for the concrete manifestations of the law in the particular case. In arriving at the application of a norm, forever, unchangeable, immutable upon the facts is employed. It is thus that the content is established. No drawing of the line, no pure form is involved, but only the most expeditious method of determining the factual foundation for the concrete manifestation of the law in that particular case. It's for the science. In arriving at the particular conclusion, an intellectual process involving the application of a norm, forever unchangeable and immutable upon the facts, is employed. Thus, the content is established. So it may follow that the content of this natural law may be incorrect. It may be poor law, and yet the standard applied be always a just one and be good law. Huh? Wait, hold up, wait a minute. So it may follow that the content of this natural law may be incorrect. It may be poor law, and yet the standard applied by which always and yet the standard applied be always a just one, and be good law. So the content may be correct, but the standard can be so the content can be incorrect, but the standard that it was applied is just and good law. So the content can be incorrect, but the form could be correct. Yeah, that follows. Just as mathematicians make errors in handling universal conceptions, so jurists err in the exercise of the standard of reasonableness, but the good idea undergoes no change or modification. The ideal harmony with which it is the aim of the constitutional law to effect between individual interests and social interests can only be attained through the correct application of a universal standard. The result of such perfect application must be, in theory, the ideal community where the purposes of different individuals are reciprocally set up as means for others with a perfect harmony of all ends, or, in other words, the result must be what Stamler speaks of as the conception of the complete harmony of all conceivable will contents. To effect such a result is precisely the problem in all freedom of contract issues. Even the most naive courts no longer regard freedom of contract as an absolute and unqualified right. Such was the attitude adduced from the older notions of natural law, but modern courts have in large parts become emancipated from such intellectual bondage. Since it follows, then, that the line must be drawn, every such circumstance presents an occasion for the correct application of a legal norm. A line must be drawn, every such circumstance presents an occasion. Older views regarded this as a purely moral question, but Stamler points out it is a question of just law and not ethical doctrine, for it is a problem of justly regulating the external conduct of those living under the law and not of forming their good intentions in relation to others. Interesting. Question of just law is not an ethical doctrine, for it is a problem justly regulating the external conduct of those living under the law and not of forming their good intentions with others. Interesting. That's an interesting perspective. Thus, it is with varying results from the application of immutable standard to constantly changing conditions we have evolved what has been called a natural law with a changing content. So thus, it is that with varying results from this application of an immutable standard to constantly changing conditions, we have evolved what has been called a natural law with a changing content. Keep doing this one, bro. I don't like how... No, and I actually... Yeah, dude, come on now. I want this green just to call it out. As society progresses, there must be similar progression in the law, for the law is or ought to be a social institution. Continual changes in economic and social conditions constantly give rise to new social interests which demand the protection of the law, for the law is pledged to protect both private and public interests. 14th Amendment especially contains evidence of this dual guardianship. The very words of the Due Process Clause imply that there must be a weighting and balancing of interests before the validity of a given process is determined. Interesting. As additional social interests increase, the scope of due process of law will be extended and the variability of the content of natural law occurs. The result is a system of natural law consisting in essence the precepts of right and law under relations empirically conditioned. The doctrine of reason is the precept of right and law which contains theoretical just law. The changing economic and social conditions result in concrete situations which constitute the materia to which the law is applied. The relationship established between the conditions empirically determined and the norm of just law affects the content. Consequently, in sustaining a 10-hour day for factory workers in 1917, the Supreme Court did not necessarily overrule the decision invalidating a 10-hour day for bakers in 1905. As assuming no mistakes or errors in the application of the standard in either case, the change in content was produced, not only a change in the standard applied, but solely by the conditions to which it was applied. To assume that the process of the court was correct in the Lochner case may be difficult to do, but the explanation can justify or at least explain the fact that both decisions are good law theoretically today. Okay, so this is a big one here. This is a key thing right here. The changing economic and social conditions result in concrete situations which constitute the materia to which the law is applied. The relationship established between these conditions empirically determined and the norm of just law affects the content. Consequently, in sustaining a 10-hour day for factory workers in 1917, the Supreme Court did not necessarily overrule the decision invalidating a 10-hour day for bakers in 1905. I'm following, but not fully. I gotta dig into it a little deeper. So the materia, well, this is the conclusion. Maybe I gotta go up here. I'm gonna sneeze. Okay, okay, so you can apply, so the content is a philosophical intention. It's not an ethical doctrine, it's a problem of justly regulating the external conduct. Okay, application of an immutable standard to constantly changing conditions. So the immutable standard would be the forma. To constantly changing conditions of materia, we have evolved what has been called a natural law with a changing content. Okay, so the content is changing. Forma, unchanging. Materia, different applications, so it can be changing. And the content also in which it is applied is changing. So it's not the format that's changing, it's the content that's changing. As society progresses, there must be a similar progression in the law, for this law is or ought to be a social institution. Continual changes in economic social conditions constantly give rise to new social interests which demand the protection of the law, for the law is pledged to protect both private and public interests. The 14th Amendment especially contains evidence of this dual guardianship. Okay, and so this will be the support. 14th Amendment. Words of due process clause. Imply there must be a weighing and balancing of interests before the validity of a given process is determined. As additional social interests increase the scope of due process of law, as additional interests increase, the scope of due process of law will be extended, and the variability of the content of natural law occurs. The result is a system of natural law consisting in essence of precepts of right and law under relations empirically conditioned. The doctrine of reason is the precept of right and law which contains theoretical just law. The doctrine of reason is the precept of right and law which contains theoretically just law. The changing economic and social conditions result in concrete situations which constitute the materia to which law is applied. Relationships between these conditions empirically determined, and the norm of just law affects the content. Relationship between these conditions empirically determined and the norm of just law affects the content. That's such that's not a simple thing. You can have so many people disagreeing on stuff, which means it's going back and forth, which means it's a little bit too volatile. To me, this seems that this explanation makes the law volatile. Does it not? That's what I'm gathering here, and I don't know if that's a good thing, but maybe it is a good thing. Maybe you do want the. I guess you do. I guess you do. So. Okay, so I guess in practicality, this is probably optimum. In practicality, this is probably optimal. I think there is a theoretical ideal, which is probably not so practical because it can be hijacked. Now let me explain. And this might not be correct, but I think this is the perspective that I have now, currently, which is that in theory, there is an ultimate correct truth and ultimate correct moral truth, in which case law's endeavor is to approximate that ultimately correct truth. And when I say truth, I guess it would be good to distinguish the elements of the material, form, and content. To get more specific about this, I have no idea. I believe that there is a universal truth being most closely resembling the form. But I also I believe that there is a universal enduring truth in the content. Like, you can't, assuming you have the same materia and the same form, the content should result in one truth, not at one point this way and at another point another way. to me, and I know that he would be arguing that it's not paradoxical because that it contains in itself various social interests of the time that are changing. But I believe that there is a universal just truth that regardless of social interests is correct morally as truth. Therefore, content should be arriving in alignment with that, regardless of the time. And so even in which current social interests of the time point to incorrect law, law should be a mechanism to push back against that. But the problem, which might be obvious, right away, is that in attempting to do that, there might be applied the wrong. You could come to the wrong truth, the wrong application, the wrong content, the incorrect content. And with the framework I am supposing, it would seem that would not provide an ability to change that once it is established incorrectly. How do you get back to the truth? And then there could also be people who disagree on what's true and whatnot. Therefore, although theoretically that sounds ideal, in practicality this may make more sense. So I guess we come full circle and back to my supporting position initially, which this becomes thus the best approximation of truth that we can thus get to in practicality. I guess that makes sense. So I'm kind of doing a full circle upon myself, closing the loop there. Interesting. But that sits okay. So that sits with me now that I walked through that. Now that I thought through that, I thought that through. I don't like it though. I don't like it. But I accept it for now. But I don't like it. But I probably don't like what I'm proposing either, in terms of how it plays out practically. Interesting. I suppose I just need to do a lot more reading. That's the only answer I've got for this. Fair enough, okay. Assuming no mistakes or errors in the application of the standard in either case. Okay, hold up. Oh, okay. Assuming no mistakes or errors in the application of the standard in either case, which to me, that is the content, right? The change in content was produced. Oh, okay. Yeah. Yeah, because if there was an error, then the content may not have been changed, because instead of the content changing, what was the change was the error introduced. So thus you need to have no errors in order for you to land on the fact that the content was changed. Okay, so the change in content was produced not by a change in the standard applied, which the standard didn't change, the form didn't change, but solely by the conditions to which it was applied is what changed. Okay, that for sure needs to be highlighted. To assume that the process of the court was correct in the Lochner case may be difficult to do. But this explanation can justify, or at least explain, okay, so he's conceding that it may not justify, but it at least explains the fact that both decisions are good law, theoretically today. Well, I don't know, justification kind of goes, maybe. I'm still trying to wrap my head around why. I mean, I understand kind of like in the abstract, but I'm trying now to understand the specific, the concrete. Sustaining a 10-hour day for factory workers means that they did not necessarily overrule the decision invalidating a 10-hour day for bakers in 1905. I want this to be blue. Assuming no mistake or errors in the application of the standard, I don't see how. These are very similar material. Well, I guess not necessarily. It can be assumed to be similar material. So you've got a 10-hour factory day for factory workers and a 10-hour day for bakers. How is the content? The content changed, but how is it that the forma does not change? What exactly is the forma then in this particular instance that allows one to conclude one content versus another? So how is it the content? Okay, I can understand the content changes, but why is it that the content would change? Because of the social interests of the time? Well, what if at one time, you accept a moral transgression? Then all of a sudden you have content supporting this moral transgression? That can't be right. But I guess that maybe that would go against the form. But then, maybe self-defense might be a better way to look at this, where it could, in situations where the right of self-defense, the form does not change, but the materia, you have two different materia cases, and the content applying this thing to ones that might seem similar actually can change. I mean, now in that case it makes sense. I guess there just needs to be more information on this. I'm not familiar with those cases, so maybe that's all it is. To assume the process of the court was correct in the lockdown case may be difficult to do, but the explanation can justify release. Okay, fair enough. I accept this. I accept this because when I think about self-defense, actually I should think about this. Or not think about it, I should a comment here. Maybe difficult to see in this example, but think about potential self-defense cases where two similar materia may conclude different content while applying same forma. And though the materia, facts of the case, I suppose, may affect the content. Resultant content. How to introduce the effect of social interests of the time, though, is still needs more clarification for me. I'm unconvinced of the social interests of the time. Maybe I need to reread his argumentation on that. To constantly changing conditions, we have continual changes in economic and social conditions constantly give rise to new social interests, which demand the protection of the law, for the law is pledged to protect both. See, this is, I guess, the one that I'm not totally in line with. Or I should say, not necessarily in line with, because that assumes I fully understand. The one I'm not fully understanding. The position he's articulating here. Continual changes in economic and social conditions constantly give rise to new social interests. Fair, I agree, yeah. Which demand the protection of the law. Law should be always protected, just point blank, regardless of anything else. It should be, I guess, protected. For the law is pledged to protect. Okay, so I buy that. I buy this. But I don't see how this is the relation to changing content. Okay, so here, contains evidence of this dual guardianship. Words of the due process clause imply that there must be a weighting and balancing of interests before the validity of a given process is determined. Weighing and balancing of interests. I think it's just the use of the word interest. I'm not fully seeing the example. As additional social interests increase, the scope of due process of law will be extended. I don't know, dude. And the variability of the content of natural law occurs. The result is the system of natural law consisting in essence of precepts of right and law under relations empirically conditioned. Okay, yeah, I guess that makes sense, as there could be it could be extending, and therefore if new conditions are occurring, thus this could be the same form, and thus resulting in a change in content. Okay, I guess it makes sense. I'm understanding. I'm buying it. Okay, fine, I buy it. Fine, I buy it. Fine. When courts are presented with a problem of the kind in question, they grapple with one of the most fundamental issues which the law affords. In each case, the general principles are usually not the subject of disagreement. No one will dispute that the 14th Amendment may be called upon to protect the private rights. Keep doing that, bro. Go down here. No one will dispute the 14th Amendment may be called upon to protect private rights. On the other hand, the police power is conceded to be power of government, which may be put forth in aid of what the prevailing morality or strong and preponderant opinion holds to be greatly and immediately necessary to the public welfare. In the word of Justice Holmes, there is no dispute about general principles. The question is whether... I already know I'm going to highlight this. The question is whether the case lies on one side or the other of a line which has to be worked out between cases differing only in degree. Any line which the law draws looks arbitrary, and still the theory of the law is that the line must be drawn. Statutes are either reasonable or unreasonable. In 1859, the Illinois court found an 8-hour law for women an unreasonable exercise of the police power. But in 1910, a 10-hour restriction was entirely reasonable. The distinction between the two statutes was expressly stated to rest upon the difference in the hours of labor allowed by the statutes. The general principles being agreed upon, it follows that the source of conflict, and also minimum wage, I guess, could be another example, because the changing economics and social interests and conditions of the time change, thus the specific number of a minimum wage may change without changing the form. Although materia is changing and the content may change, or the content can be even the same in this case, because just the materia changed and the content is in accordance with... Well, maybe suppose the content can change too. Although the general... This is all very theoretical, man. This is not like... That's why the law is always so open to interpretation or open to argumentation. But in 1910, a 10-hour restriction was entirely reasonable. No, hold on here. The general principles being agreed upon, it follows that the source of the conflict and difference of opinion lies in the application of the standard and the method of approach. This is invariably true when courts are presented with the necessity of applying a standard, a norm of unconditioned universal validity. But it is in the intellectual process thus involved that the natural law with the variable content is born. Almost got me. Oh, I guess they did. Right there. Content is born, for the existing body of dogma is here carried, as Holmes says, into its highest generalizations by the help of science is useful, and so is history, but a genuine philosophy is indispensable to complete the legal process in problems under discussion. Science can aid in ascertaining the facts, and particularly where economic and social phenomena are involved. History is serviceable to illustrate how rules and principles have been applied to concrete situations in the past, and to thereby assist in meeting such and similar situations in the future, but never as self-sufficient premises that which to deduce by syllogistic logic rules to govern every case that may arise. Science and history supplement and augment each other. The tendency of constitutional law in the past to follow exclusively the path of history has, as we have seen, failed, for law cannot be developed, as Stammer says, by casual historical observation, nor yet empirically. On the other hand, the content of just law cannot be derived solely from ethics or morals. Even when fused into and amalgamated with law, only the form can be thereby affected. When correctly applied with science, history, and philosophy doing their part, perhaps the natural law with its variable content may reconcile the two great demands made upon any jurisprudence, namely, the need for fixity and stability and the necessity for flexibility, that the law may not be stunted in its growth and development, regardless of the ultimate results attained by the present tendency. It is serviceable to examine our constitutional law in the light of valid critical theory, distinguishing form and matter and content, because, in the words of Del Vecchio, criticism has taught us to distinguish the truth of phenomenon from that of the ideal norm which governs it, while offering us a means of recognizing its gradual reconciliation in history. Criticism has taught us to distinguish the truth of phenomenon from that of the ideal norm which governs it. Basically, what I got from this is that every law has three parts: the materia, the form, and the content. Natural law is the philosophical changing part of everlasting jurisprudence that is needed, basically, in short, in a very brutish, terribly flawed way of summarizing this. I don't know if I did great highlighting on that. I mean, I highlighted some good stuff, but the way I'm highlighting these, I don't really like. But overall, pretty good. Okay, cool. Cool. Here? Yeah, I think it was this one. Natural Law and American Constitutional Theory. Wait, which one was this? Was the first one? Okay, this is all Magna Carta stuff, history, okay, so now I'm on here. So now I can continue with this and learn about the Scottish Enlightenment. Influence of Scottish Enlightenment, and then Scottish Enlightenment and American Revolution. And then natural law in the American Constitution. So jumping back to natural law in the Constitution. This time in Fordham Review. 1953, old school. Oh, I can highlight this? Yo! It's like a newspaper, bro. This is short, too. And then, going additional metaphysics, epistemology, and natural law theory. American Journal of Jurisprudence, and then naturalism and ethics. Okay, interesting. This first one was garbage. This was just the first garbage, for sure. The worldviews, this was really great. This one was great. Great. Let's see. What is this? 6 pages only? NLNRAC.org. What is that? NLNRAC. Natural law, natural rights, and American constitutionalism. When in the course of human events it becomes necessary for one people to dissolve the political bands which have connected them with another and to assume among the powers of the earth the separate and equal station to which the laws of nature... Hey, go back. I was reading that. To which the laws of nature and of nature's God entitle them, a decent respect to the opinions of mankind requires that they should declare the causes which impelled them to the separation. Declaration of Independence. Repeal the Missouri Compromise, repeal the Declaration of Independence, repeal all past history. You still cannot repeal human nature. It will still be the abundance of man's heart that slavery extension is wrong. Abraham Lincoln. I would agree with St. Augustine that an unjust law is no law at all. An unjust law is a human law that is not rooted in eternal law and natural law. Okay. So what is this? So this is by We the People Project of the National Endowment for the Humanities. Classical and medieval sources of natural law. Platonic philosophy, natural law, Aristotle, natural law and the founders, Cicero and the natural law, Aquinas' theory of natural law, late medieval transformations, the Protestant reformers of natural law, and Richard Hooker in natural law. Okay, so let's click this and look. Interesting. The Witherspoon Institute. Let's look them up. Let's do a little dive into these guys. Witherspoon Institute. Who are you? Witherspoon Institute, a U.S. conservative think tank. Surprised because this guy's professor's pretty liberal. Pretty progressive, in fact. Natural law view of marriage. We got a reading list. Main syllabus. Interesting. I wonder what they advocate. Public meaning and benefit of marriage. Alliance Freedom. Katie Faust's story. Humanum. Destiny of Humanity, Meaning of Marriage, Witherspoon Institute. Rabbi Lord Jonathan Sachs. Richard Reeves. Okay. Richard Reeves, I've heard his name actually.
There are some studies that suggest, for example, that being without a close friend, being lonely, is as...
The Big Think. Michael Orr. Bill Nye the Science Guy. Oh no, this can't be good. Neil deGrasse Tyson. Oh no, this can't be good. Richard Reeves is maybe good though. Anyway, what else are they? What other sources? I don't really know any of these people. I don't know what any of these sources or readings really are. Katie Faust. They have. What is their teaching on this? What on earth? I feel like I shouldn't be. So they have a particular view on marriage and seven loves, friendship and marriage, same-sex attraction, loving those with same-sex attractions updated. Then divorce. Who is this Katie Faust person? Because they're citing her a lot for reading. Who's Katie Faust? Oh, is this? Yeah, okay, interesting. What a weird connection. I just watched the interview with her, a YouTube video interview of this person. I thought this person was great. Oh, she's also radical. She's so radical in her position. Oh, that's awesome. I loved her. Okay, so maybe this is good. Interesting. What am I even on here? I don't even understand where I got to this. Interesting. The hookup culture? Economics of sex? Okay, I'm not gonna do that. Okay, so they're probably against casual. Dating? Cohabitation? Marital fidelity? Communication, importance of fatherhood. This is long. This is just going on forever. Interesting. Who we are. Who are these people? Rooted in natural law. Look at, what is that? Nice hat, bro. What we cheer for. Permanent and exclusive union. Oh, hey. Yo, maybe that's pretty good, actually. Reading lists. young pro, college students. Interesting. Interesting. Okay, that was kind of a weird tangent. I'm just trying to find out who these people are. Witherspoon Institute. Public discourse. Okay, I don't know if I care about their think tank. Okay, whatever. Where was I? Oh yeah, here. Early modern is Hobbes, Locke, Natural Law and Law of Nations, Montesquieu. American Founding Constitutionalism, Contemporary Theory. Critics, Machiavelli, Guicciardini, Social Darwinism, American Progressivism, Oliver Wendell Holmes Jr., Natural Law and Legal Positivism, John Rawls. Ooh. John Rawls is critic of natural law. Hold on, let's go to Legal Positivism. What is this? Legal Positivism and Natural Law Theory by Dartmouth College. Published in 2011. John Rawls. Quite interesting. I'm gonna, let's see, back. I'm gonna save this page for sure. Save. A lot of readings to do. What time is it? 3:30? Okay, I guess I better get to the other stuff now. Okay, I read one. I really want to get through these though. These are some pretty interesting stuff. And there's also... It's not going to move that there. This... I'm not going to read. There's also... What's the other one? Cybersecurity policy. Technology and policy. There's also this. History of the Internet. Oh, this is short. Oh, no. Wait, what? How did I skip so many pages? Oh. Whoa. Oh, that's the Zoom. Okay. Oh, this is an old school paper, 2003. Anyway. So much reading. Unreal. So much reading to be done. Anyway. Let's read this stuff though. Why is this not? Okay. Oops. Let me not do that. Let me do this. Uh-oh. Did I just show? Dang. Wow. I just showed that, didn't I? I mean, there's nothing really compromising, but still. I just showed that. That's kind of stupid. Let me see. Kind of. You can't really take that much. You can't really take anything from that, but still. Still. I have 15 days left. But I'm looking good so far. As long as I'm still progressing at this pace. Let's see what I have. Oh, I just clicked that. Okay. I don't know why this is not working sometimes. Okay, what am I? Now I'm getting into WLANs. How WLANs work. What's going on here? Okay. I finished one of these, right? This one. By the way, I was just thinking it was so good to reread that document because I feel like the first time I didn't grasp what it was saying, and now, like now I have a pretty good understanding of what it was saying, especially as it relates to, or maybe not the best, but at least a good understanding of like how the idea of how laws have the three components of materia, forma, and content, whereas natural law is really informed in the content of it. Anyway, I don't know why I thought of that, but that was good to reread that. So good.